Get ready for the dictation. On the count of 3, 2, 1, start. The corporation has carved out two classes of dependents of the deceased employees in respect of claims for compassionate appointment. The reason for the disqualification of the dependents of an employee who died in an accident involving the vehicle of the corporation is to avoid extra burden on the appellant corporation. In such cases, the appellant corporation has to pay the compensation under the Act and also to provide compassionate appointment to the dependents of the deceased employee. In a case where the vehicle of the appellant corporation is not involved in the accident, the compensation under the Act is not the liability of the appellant corporation. It cannot be said that the dependents of an employee who claim both compensation under the Act and compassionate appointment from the appellant corporation are on the same footing as the dependents of the deceased employee whose claim under the Act against a private owner or an insurance company and compassionate appointment from appellant corporation. The dependents of a deceased employee who claim compensation from the corporation under the Act and compassionate appointment from the appellant corporation from a separate class. It is well settled that though Article 14 forbids class legislation, it does not forbid reasonable classification for the purposes of legislation. When any impugned rule or statutory provision is assailed on the ground that it contravenes Article 14, its validity can be sustained if two tests are satisfied. The first test is that the classification on which it is founded must be based on an intelligible differentia which distinguishes persons or things grouped together from others left out of the group. And the second test is that the differentia in question must have a reasonable relation to the object sought to be achieved by the rule or statutory provision in question. Having held that the classification of the two categories of dependents of deceased employees is reasonable, what remains to be examined is whether there is a rational nexus of the classification with the objective sought to be achieved by the regulations. 4. The intentions with which regulation is made is to obviate the liability of the corporation in payment of compensation under the Act and to provide compassionate appointment to the same person. We find there is a rational nexus between the basis of classification and the object sought to be achieved by the regulation.